Sure. Messenger, come in, please. Thank you. We're back in session. The jurors are again present. Sharon Hinton is on the stand. And did you have further questions, Ms. Holt?
I did, Your Honor.
Okay.
Agent Hinton, you had described before you broke the process that you went through about extracting the DNA from the known samples, and extracting the DNA that you could from the questioned pieces of evidence that came in. Did you then go through and make a comparison of the two?
I did.
And I'm just going to ask you about your results with regard to your items 1, 2, and 3, which were the swabs from Laura Ackerson's car. Can you describe your results with regard to those swabs?
Sure.
Now, you
No
arrived
DNA
at,
profile was obtained from the swabbing from the exterior door handle, which is our item 1. For item 2, no interpretable DNA profile was obtained from the swabbing from the front passenger door handle. This DNA profile is insufficient quality or quantity for comparison purposes. And for item 3, the DNA profile obtained from the swabbing from the steering wheel and the gear shift is consistent with a mixture of at least 2 contributors. The partially predominant profile is consistent with the DNA profile of Laura Ackerson, but no conclusion can be rendered as to the contribution of the DNA profile from Grant Hayes or Amanda Hayes to the mixture due to insufficient quality or quantity.
When you use the predominant profile, you've earlier talked about the marbles in a bowl. When you talk about the predominant profile, what do you mean?
That you have more of one person's DNA on a particular item. In this case, it was a mixture of at least 2 people. So again, with my marbles in a bucket, you have a bucket of blue marbles and you may have a few red marbles thrown in there. So you have mostly one person's DNA profile in there, and then you have a little bit of a DNA person. You see their DNA profile in there. In this situation, it wasn't enough of the other person's DNA profile for me to conclusively say that it belonged to one person versus another.
And you had received what you've identified as 4-1, which has previously been described as the cutting from the white towel that was recovered from the trash. What analysis did you perform on that cutting?
It would have been the same DNA extraction, quantitation, and amplification that I would do on all of the samples.
And what was your result with regard to that analysis?
For the cutting from the towel, item 4-1, no DNA profile was obtained from that cutting.
In this case, Agent DeHaan, who just testified, indicated that she took that cutting after she got positive indications for the presence of blood. Is that unusual to you that she would have gotten positive indications for the presence of blood and submitted it to you, and you would not have been able to get a DNA profile?
No, that happens a lot. Sometimes the cell itself may be there, the actual the items on the exterior of the cell that they use for their chemical indications may be there, but once it is opened up and the DNA is taken out, the DNA may be damaged, or just there may not be enough of the DNA there for me to generate a profile from.
And what kind of things would cause the DNA to be damaged?
The environment, if it's exposed to light or water, could damage it. Chemicals can damage DNA.
So the fact that she got positive indications for the presence of blood, but she did not obtain a DNA profile, to you does not indicate that there wasn't blood there?
I'm sorry.
The fact that she got positive indications for the presence of blood in her testing, but you did not receive a DNA profile, that does not, what does that mean?
That the sample may have been blood on the sample. It just wasn't enough, or it was just too degraded or damaged for me to get a DNA profile from.
You indicated that you also received a item number 5 on your report, which is a 3M disposable respirator.
Yes.
And this was a item that Agent DeHaan indicated that she didn't test, but that she passed on to you to attempt to get DNA from this sample.
That's correct.
And what were you looking for with regard to this particular item of evidence?
In this situation, it was a respirator, like a half-face respirator that you'd wear over your nose and mouth. So I would have taken cuttings from the area where your nose and your mouth would have been to see if there was any saliva or cells that would have been in that area is what I was looking for, to see if I get any DNA off of there.
And were you able to get any DNA from that respirator?
No, I was not.
With regard to item number 7 in your report, which is identified as 4 latex gloves and another respirator, a 3M disposable respirator, do you recall what happened when you opened up that particular package?
Yes. When I opened that package up, it had 4 blue latex gloves and a respirator. And the blue gloves themselves, they had some reddish-brown staining on them, which I wasn't sure what it was. So I would call Agent DeHaan to come back into my office and test them to see if it gave any chemical indications for the presence of blood. And she did, and it was positive for chemical indications. So what I did is I took a separate swabbing of just that area, just the brown stains, to see whose possible blood or substance it could have come from. And then I took swabbings from the gloves themselves to see if I could find out, who was actually wearing the gloves.
And with regard to those blue gloves, when you pulled them out, Agent DeHaan held them up, and they had been stapled together so that they were all kind of, is that how they were when you opened them up?
No, they were loose. I just stapled them together just to keep them intact and to identify them.
And you indicated that you took, after Agent DeHaan came in and got a positive indication for the presence of blood, that you took a swab just from the brown stained area?
Correct.
And what was the result of your analysis of the brown stained area?
The DNA profile obtained from swabbing from the brown stains on the outside of the blue gloves, which is my item 7-6, matched the DNA profile obtained from Laura Ackerson and did not match the profile of Grant Hayes and Amanda Hayes.
And so that profile, was it just one profile, DNA profile?
Correct.
And you indicated this brown stain, was it on more than one of the gloves?
Check. Yes.
And did you take a swabbing from each of those locations on the various gloves?
I did. As one item, since the gloves were commingled together, I just took one swabbing and swabbed both of the gloves together.
And where on the gloves were those stains located?
They were on the outside of the gloves, I guess would have been like on this area of the gloves.
And at that point, did you also have in that packaging a 3M respirator?
I did.
And did you do any analysis on that?
I did.
And what was your result there?
The cuttings from the respirator, that was my item 7-1. Examination of the cutting from the respirator revealed the presence of 9 alleles and is insufficient quality or quantity for inclusionary purposes. No conclusion can be rendered as to the contribution of the DNA profile from Laura Ackerson, Grant Hayes, or Amanda Hayes to the mixture due to insufficient quality or quantity. And that basically means that basically when you have your DNA profile, like I said, there's 16 locations that you have. So there's a total of like basically 32 alleles that you can get, that you get half from your mom and half from your dad. In this instance, I only got 9 out of that 32. So that's why I was saying that it wasn't enough, it wasn't of sufficient quality for me to make any comparisons to say that it was or was not a person.
And you had indicated with regard to the blue gloves that you had swabbed the reddish brown stain and found that profile to match the victim, in this case, Laura Ackerson.
Correct.
And you indicated you also did some additional swabbings to see if you could find out who was wearing those gloves.
Correct.
And where did you take swabbings from for that purpose?
I would have taken swabbings from the outside and the inside of the gloves.
And what was the conclusions that you came to with regard to those swabbings that you took from the inside and the outside of those gloves?
Okay, 7-1. For 7-2, the DNA profile obtained from the swabbing from the blue latex gloves is consistent with a mixture of at least 2 contributors. Partially predominant profile matches the profile of Laura Ackerson, and no conclusion can be rendered as to the contribution of Grant Hayes and Amanda Hayes to the mixture due to insufficient quality or quantity. This mixture does contain at least 1 male contributor, though. For 7-3, no DNA profile was obtained from the swabbing from the blue latex gloves. For 7-4, the partial DNA profile obtained from the swabbing from the blue latex gloves is consistent with a mixture of at least 2 contributors, and no conclusion can be rendered for Laura Ackerson, Grant Hayes, or Amanda Hayes due to insufficient quality or quantity. And 7-5, examination of the swabbing from the blue latex gloves revealed the presence of 3 alleles and is of insufficient quality or quantity for inclusionary purposes. No conclusion can be rendered as to the contribution of the DNA profile from Laura Ackerson, Grant Hayes to the mixture due to insufficient quality or quantity. The DNA profile obtained from Amanda Hayes is excluded as a contributor to the mixture. And 7-6 was from the swabbing from the brown stains on the outside of the blue gloves.
Basically, when you got these blue gloves, you took several different swabbings, is that right? And
Correct.
they were numbered 7-1 through 7-6.
Correct.
And 7-6 is the one that you've identified that came from the brown stained area from the outside of the gloves, is
Correct.
that right?
Correct.
And 7-1 through 5 were from both the inside and the outside of the gloves?
Correct.
Okay. And with regard to some of those swabbings, you didn't have enough information to make any decisions. There wasn't enough DNA to really even allow you to make any kind of comparisons. Is that right?
That's correct.
And with regard to other of those swabbings, you were able to have enough to tell that it was a mixture, is that right?
Yes, ma'am.
And with regard to one of those, you were able to say that it was a mixture and that you knew that at least one was male.
Correct.
And with regard to another one, it was a mixture, and Amanda Hayes had been excluded as a contributor to that mixture.
Correct.
And so there were various different, with regard to each of those, some of them you could make some opinion as to who could have been a contributor and some could not, is that right?
That's correct.
And at least one of those involved a mixture on which you could not say whether or not it was Amanda Hayes. You could not include her or exclude her, is that right?
Correct.
With regard to you also have some additional gloves, some yellow gloves, dish gloves.
I did.
And with regard to the yellow dish glove, that would be your item number 8.
Correct.
And were you able to get a DNA profile from those gloves?
No DNA profile was obtained from the swabbing from the yellow dishwashing gloves.
And did you observe any brown stains on the yellow gloves as you had with the blue gloves?
No, ma'am.
The linen closet door frame swab, did did you also examine that, your item number 12?
I did.
And what were the results of, with regard to your analysis of the swab from the linen closet door frame?
No DNA profile was obtained from the swabbing from the linen closet door frame.
And again, this was an area which had tested or given positive indications for the presence of blood by Agent DeHaan's test. Is that right?
Correct.
Agent Hinton, did you also receive a request to do some analysis with regard to some hair roots that had been recovered and which was described as item number 10, being debris from the drain area?
I was.
And did you perform kind of the same process, the DNA extraction, and make comparison to the known standards in this case?
Yes.
And what were your results with regard to the roots from the hair drain?
For items 10-1, 10-2, 10-3, and 10-4, no DNA profile was obtained from the roots that were removed from hairs from the bathtub drain.
And Agent Remy has testified about her, examining items and finding items that may be suitable for analysis with DNA, and she's indicated she passed those on to you. Items that she finds suitable for DNA analysis, do you always obtain a DNA profile from those items?
No, we do not. Sometimes, again, the tissue could be damaged for any reason, and on the outside they may look perfectly fine, but once the DNA is extracted, it could have been damaged, or inhibitors could be present.
And you've used the term before, inhibitors. What do you mean by that?
Inhibitors are things that will keep the sample from amplifying, that 0.1% from amplifying. For example, the dye in blue jeans is known to basically get into the DNA and keep us from replicating it or multiplying it. So that's what an inhibitor does. It gets in there, and you can't amplify that 0.1%. So it'll come out as no DNA profile, or you may get a partial profile. It just depends on how significant or how much of the inhibitor is present in the sample.
You had received a tissue sample, what was identified as a tissue sample from a fence that had been recovered from Texas.
Yes.
Were you able to obtain a DNA profile from that tissue sample?
I was not.
And you also received a root from a hair that was found from on the blanket on the hutch. Were you able to get a DNA profile in that case?
A partial profile. The examination of the root removed from the hair from a gray blanket on top of the hutch revealed the presence of 7 alleles and is of insufficient quality or quantity for inclusionary purposes. No conclusion can be rendered as to the contribution of the DNA profiles from Laura Ackerson, Grant Hayes, or Amanda Hayes to this profile.
And that again is because there's insufficient information.
Correct.
With regard to the coffee can that was swabbing from the coffee can on the boat, were you able to obtain any DNA profile?
No DNA profiles obtained from the swabbing from the coffee can in the boat.
There's been testimony from Agent DeHaan about taking a swabbing from the handle of the vacuum cleaner that had been recovered from the trash.
Yes.
And did you receive that and examine that particular item?
I did.
And what was your result there?
The partial DNA profile obtained from the swabbing from the handle of the vacuum is consistent with a mixture of at least 2 contributors. No conclusion can be rendered as to the DNA profile of Laura Ackerson, Grant Hayes, or Amanda Hayes to the mixture due to insufficient quality or quantity.
And with regard to the DNA, you previously testified about chemicals and how they can degrade DNA or make it difficult for you to obtain a profile. And a chemical such as bleach, is that one that would have that effect?
Yes, ma'am.
And are you familiar with hydrochloric acid and what effect that has on tissue and DNA?
Yes, hydrochloric acid can actually eat through your skin, the muscle, and even damage the bone. So a prolonged exposure to that substance can totally damage your DNA down to your bones.
Thank you, that's all I have.
Ms. Gaston, any questions?
Yes, thank you, Your Honor. Good afternoon, I think.
Good afternoon.
Agent Hinton. If I may just go through the list of the items that you received.
Okay.
First, let's talk about the driver's door handle on the Ford Focus.
Okay.
You have no DNA. Correct.
The driver's door handle, that's correct.
The passenger door on the Ford Focus, no DNA, correct?
No interpretable DNA profile.
The steering wheel on the Ford Focus, you have a mixture with the prominent contributor being Laura Ackerson.
Correct.
On the white towel obtained from the trash dumpster, you found no DNA.
Correct.
Now, you talked some about there having been a preliminary test done that tested positive for blood.
For the chemical indications of blood, yes.
And on that particular item, no confirmatory tests were done to determine whether it was or was not blood.
Correct.
And you found no DNA in the sample.
Correct.
You also indicated that there was a 3M disposable respirator that you examined that had no DNA on it.
Correct.
Yellow gloves had no DNA, correct?
Correct.
The linen closet, the sample from the linen closet had no DNA in it, correct?
Correct.
And that's also one where a preliminary test had been done that indicated a positive indication for the presence of blood.
Correct, for chemical indications for presence of blood, yes.
But that sample, that's another sample in which there was no confirmatory test done to determine whether it was or was not blood.
Correct.
You just found that there was no DNA in the sample, correct?
Correct.
The root hairs that were recovered from the bathtub drain produced no DNA, correct?
Correct.
The gray T-shirt produced no DNA, correct?
No, an unknown male DNA profile was obtained from the gray, the piece of the gray T-shirt.
When you say that when you indicate that an unknown male can be identified on a particular item, tell us how you're able to determine that it's a male's DNA.
Of the 16 locations that we test for, one of them is called amylogenin, and that's basically your sex identifying marker. So a male will have an X and a Y, and the females will have 2 X's. And in this particular sample, there was an X and a Y, so that's how we identify it as a male sample.
So females always have 2 X chromosomes, and males always have an X and a Y chromosome.
Correct.
And you found an X and a Y chromosome on that shirt.
Correct.
The hair from the hutch that was recovered from the blanket in Texas had no DNA on it, did it?
The examination, it had, it did have DNA on it. It was only 7 alleles, but it was insufficient quality or quantity for me to make any conclusions.
The coffee can from the boat in Texas had no DNA on it, did it?
Correct.
The vacuum cleaner handle, and that's the yellow, I'm assuming that's the yellow vacuum cleaner deal, or do you know?
I didn't see it. I just saw swabbings.
That had some alleles on it, but it was insufficient to make any kind of determination, correct?
It was, well, actually, it was consistent of a mixture of two contributors, but no conclusion could be rendered as to who they belong to.
And the tissue from the fence from Texas had no DNA on it, did it?
Correct.
Now let's talk about the 4 latex gloves that were recovered from the duck.
Okay.
On one of those had no DNA on it at all, correct?
Correct.
One of those had only Laura Ackerson's DNA on it, correct?
Correct.
And that DNA sample came from the outside of the glove, am I correct?
Correct.
You found that on one of the other gloves that Laura's DNA was the predominant DNA on that glove, correct?
Correct.
And that involved a mixture which you could not identify.
Correct.
And I think on the last glove, you indicated that there was also a mixture obtained from that glove, and you were able to absolutely exclude Amanda as one of those contributors.
Correct.
Do I have a moment, John?
Sure.
Ma'am.
All right, anything else?
Just one question, following up on what Mr. Gaskins was just asking. He was asking about one glove and another. I mean, did your swabs, were they taken one per glove?
No, it was, since they were all mingled together, they were all just kind of like swabbed together, like the outside and then all the inside that were swabbed.
And the one that you got a match to Laura's DNA, and that was taken just from the brown swab, I mean the brown stain area.
Correct.
And the one where you had the mixture that had the predominant being Laura's DNA, was that taken from the brown stained area or from various locations?
That had been various locations. When I was, the other swabbings I used, I avoided the brown stained area.
That's all.
All right, yeah.
Nothing else.
Okay, thank you. Thank you, Allison. You can stand down. You retrieve your evidence, please. Tell me who your next witness is.
John Sargent.
Okay. Come on up, Ms. Sargent. You be sworn, please.
I do.
Thank you.
Yeah, maybe approach.
All right. You can have him state his name and his occupation.
Could you state your name, please?
Jonathan Sargent.
And how are you employed?
I'm an attorney.
Ms. Sargent, I believe that I've had a hearing with you previously in which you have indicated to the court that in July of 2011 that you were an attorney for Laura Ackerson. Is that correct?
That's correct, Your Honor.
Okay, and that you, pursuant to your legal responsibilities under as an attorney, have indicated concern about the attorney-client privilege. The court had a little hearing. I think I determined that the estate and the executor of the estate of Laura Atkinson has waived any privilege, and I've directed that you testify with regard to your conversations with her. And so you are again instructed today that under the circumstances, I believe the interests of justice would require that you be compelled to so testify.
I understand.
Okay, thank you. Go ahead.
Mhm.
Mr. Sargent, you indicated you're employed as an attorney. What area do you practice in?
I'm a board certified specialist in family law
And where is your office located?
in Kinston, North Carolina.
And during the course of your practice in Kinston in the field of family law, did you have occasion to come to know Laura Ackerson?
I did. I represented Laura Ackerson in her child custody matter.
And do you recall the first time that you met with Laura Ackerson?
Yes, I do. It was June the 15th of 2010. She came to my office.
And at the time that she came to the office, what was the situation with regard to the custody?
At the time she came to me in June 15, 2010, she had some papers that she had been served that day. Those had been filed with our district court in Lenoir County. And what she had with her was what we call an ex parte custody order that gave Mr. Hayes temporary custody of both of their children.
And at the time that you met with Ms. Ackerson, that order had been entered and was in effect?
That's correct. It had been entered on June 15th, and I think she had just received it. And and the law enforcement had just been to her house and taken her son Gentle to deliver to Mr. Hayes.
And did you understand?
Kind of toward the end of 2009, they had been living somewhere in the Virgin Islands, and Laura had moved back to Kinston to stay with Mr. Hayes' parents, mostly because Gentle, the younger child, needed to have some surgery that they couldn't do in the Virgin Islands. So they moved back to Kinston. Mr. Hayes, I understand, stayed in the Virgin Islands. Both children were with Laura at that point when she came to Mr. Hayes' parents' house in Kinston. Sometime in about February of 2010, Laura agreed to let little Grant, their older child, go stay with his father in New York for 2 weeks. So little Grant left about February the 14th, right around Valentine's Day, and went back to New York with Mr. Hayes. After that, Gentle stayed with Laura up until June the 15th. When Mr. Hayes' attorney filed those papers.
And you indicated earlier that this was a ex parte order. What does that mean?
Ex parte is a term we refer to that just means without the other side being present. So under our law, if you can allege that a child is in danger or that there's some emergency, you can go directly to a district court judge and ask for an ex parte order without the other side ever being there. And that if that judge is so inclined, the judge can grant you emergency custody or ex parte custody of that child. Those orders are generally only good for 10 days. At the end of 10 days, you have an opportunity to come back into court, hopefully with both parties present, to review whether that order should stay in effect. And that's what she had in her hands, was a ex parte order.
And so as of that day, that order had been delivered to her, and Gentle had been taken from her and turned over to Grant Hayes.
That's correct.
And did you learn that that prior to that happening, that she had taken some steps herself to try to file a custody action?
That's correct. And after little Grant went to live with his father in New York and was supposed to be there for 2 weeks, when little Grant didn't come back after 2 weeks, I think she went back and forth with Mr. Hayes in March trying to find out if he was going to send little Grant back to stay with her. When it got to the end of March, Laura realized he wasn't going to send little Grant back, so she filed a pro se, which just means without an attorney, child custody action in Lenoir County there in Kinston. She did that on her own, and so there was a case pending, which she filed on March the 29th of 2010.
So that had been filed, it was still pending, and then this ex parte.
But there had been no hearings or anything set in that case yet that Laura had filed.
And at that point, did she engage your services as a family law attorney to assist her?
Yes, ma'am.
And what specifically was the goal, or what did she retain your services for?
Well, the first thing we had to do was get ready for the return hearing. When they got that order on June the 15th, the judge set a hearing date on June the 25th, 2010. So we basically had 10 days to try to get all the facts from her, to line up witnesses and get ready to have a hearing about whether or not, where these kids should stay on a temporary basis. So I met with her, I think she came in that day and just brought me the papers. I met with her again on the 17th of June to kind of get the history from her. We met again, I think, one more time before the 25th. So our first priority was to deal with the return hearing on the 25th of June.
And so what you've indicated that initial ex parte order was good for 10 days, and then there was a hearing set for the 25th.
That's right.
And was that in relation to that ex parte order, deciding kind of where to go from there?
Yeah, at that point, the judge gets a chance to hear from both parties and then decides, what the judge is going to do on a temporary basis. The judge can dissolve the order, the judge can continue it in effect, or the parties can reach an agreement, which is usually what happens is, at that point, if both parties have attorneys, we meet and try to work out some kind of temporary arrangement.
So on June the 25th, did you in fact go to court with Laura Ackerson?
Yes, we did.
And what happened on that day in court with regard to the custody matter?
On June the 25th, 2010, I was in court with Laura. Mr. Hayes was there with his attorney, Mr. Hill. Bill Hill is his attorney at that time. We met with the judge. Through some discussions between the attorneys, we reached an agreement. We ended up putting that agreement down in writing. It was pretty long, fairly detailed. It addressed a number of different points. And then the parties signed it and the judge signed it. And so that temporary agreement was what was going to govern from that point forward.
And with regard to, I know you said it was long and involved, but in terms of the basic idea of where the children were going to be, or where the children were going to live, what was that agreement?
Well, as far as where the children were going to live, we agreed that the two children would stay with Mr. Hayes during the week, and Laura would have them every weekend. So she would pick them up on Fridays and then return them on Sundays, and they were going to meet at a gas station, I think in Wilson, which was a public place. He was in Raleigh, so that was roughly halfway between where they lived.
And was that all laid out as part of that agreement, that is, the exact location of where the transfers were to take place?
Yeah.
And when they were to take place?
Yes, ma'am. We put in the idea in these agreements is that obviously the people can't get along, or we wouldn't be in that situation. So we try to be as specific as we can on everything so that there's no disputes. We don't like to leave anything for them to agree on. So we addressed the pickup time, the drop-off time, the pickup location, how long they were with Laura. And that was something we had kind of agreed on largely because, Laura had just moved out of Mr. Hayes' parents' home. So she was kind of in a position where she was trying to establish a place to live. She wasn't working at that time, so she needed to find employment. She had to have a way to support her children. And so really it kind of made sense at that point, at least on a temporary basis, to let the children stay with Mr. Hayes during the week because he was a musician and he did his work on the weekends primarily. So it kind of worked out better for him to have the kids during the week and her to have them on the weekends because we figured she was going to be working during the week. Mm-hmm.
Was one of the parts of that agreement related to a psychological evaluation?
Yes, that was another big point for us. There was really three major parts to this agreement. One was the actual temporary schedule that we just talked about. The next part was we agreed to a child custody psychological evaluation, which is a special evaluation that we do sometimes in family law cases, where we choose a qualified expert and we send both parties to that person and we let them do an evaluation of really the entire situation. So they would meet with both parents, they would talk to extra collateral witnesses that either parent thought were important. They would do psychological testing on both parties. They would interpret the results of that psychological testing. They observed interactions between each parent and the children. It's a very detailed evaluation. And we did put it directly in that order that these people were going to get a psychological evaluation on the whole situation. And that was largely because in the papers that Mr. Hayes filed on June the 15th, they had alleged that Laura was, mentally unstable. So that was part of their allegations, and part of our allegations were that Mr. Hayes was a substance abuser and that he had mental health issues of his own. So when you've got mental health issues being alleged by both parties, I think everyone felt like the best thing to do was to have a full evaluation.
And in terms of the evaluation, you've indicated that it's, in-depth, that it involves interviews and observing interactions. The ultimate goal of the evaluation is for that person to make some kind of recommendation with regard to the children and who they should be with. Is that part of the goal?
Yeah, that part of the goal. Part of it is to make findings, because there's a lot of different allegations in these kind of cases. One party is saying something about the other party. It goes back and forth. So what we're looking for, number one, is for the evaluator to make some findings about, this is a real issue, this is something we need to worry about, or this is not a real issue. So they make a whole lot of findings about, different things that have happened. Then they go on to make recommendations. And, we were expecting certainly a recommendation on placement and a lot of other different issues. Mm-hmm.
And what was put into place with regard to the psychological evaluation in this particular case?
We agreed we were going to have a psychological evaluation with Dr. Ginger Calloway, who's a very well-known psychologist here in Raleigh. We agreed that they would start that evaluation immediately because we didn't want to wait. We didn't really intend that this temporary arrangement was going to last forever. We wanted to go ahead and get the evaluation. We also agreed that Mr. Hayes was going to pay the cost of the evaluation because Laura just didn't have the funds at that point to pay part of it. So we agreed Mr. Hayes would pay the cost of it, and the judge would have discretion when the case was heard to apportion that cost back between either party and however she saw fit.
So the upfront cost was to be paid by Mr. Hayes.
That's
and
correct.
then,
Mm-hmm.
Later down the road, if a judge determined that some more of it should be borne by Laura, then she would pay in.
Yeah, and that's typical. Sometimes the judge will say, this is how we're going to get it paid for up front, but I'm reserving the right that after I hear all the evidence, I can decide that should be shared between the parties or however the judge sees fit to do it.
And so this was part of the agreement that was entered into on June the 25th of 2010. Is that right?
That's correct. And there was a section about the Gentle being able to get the surgery, which was another big issue of contention.
And so were those I know earlier you said there were three main things that happened on the 25th.
Yeah, we put a temporary custody schedule in place while we were going through the evaluation. We agreed to the evaluation and how that would proceed. And then we made we entered an agreement that Gentle was going to go ahead and get the surgery he needed by a certain date. And then the doctor that was going to do that surgery, and that both parties will cooperate with the surgery. There had been some dispute between the parties about the surgery, and both of them essentially were claiming that the other one was delaying the surgery. Laura was saying she wanted to get the surgery, but Mr. Hayes didn't want it to happen right away for whatever reason, and then Mr. Hayes had claimed that it was Laura that was blocking Gentle being able to get the surgery. So in that regard, we resolved that by agreeing that yes, Gentle would get the surgery by a certain date. We agreed to this doctor and that both parties would cooperate. And part of the schedule was also, we figured that Gentle was not going to be doing the visits the first few weeks after the surgery, so we kind of built that into the schedule. That Gentle's going to be with, he was going to be on bed rest and not be able to travel for a couple of weeks. But that only lasted probably 2 or 3 weeks. Mm-hmm.
And at that time, was there anything put into place for midweek visits? Do you recall?
We didn't, not that I recall any midweek visits. The parties were always free to try to, if they wanted to work out a visit some other time. Our orders are basically, this is what you're required to do. If something comes up and you want to work together, we as family law attorneys always encourage our clients to try to work together. They don't always do that, but we certainly encourage them to do other times as they might agree. Mm-hmm.
Madam First Witness.
You may.
Mr. Sergeant, I'm handing you what has been marked for identification purposes as State's Exhibit 501, and ask if you recognize that.
Yes, ma'am, I recognize it.
And what is State's Exhibit 501?
This is a typed version of the agreement we reached on June the 25th of 2010. Usually when we're in court that day, we do a handwritten version that the parties sign and the judge signs, so it's binding that day. And then I had this typed up and then submitted it back to the judge, and it was signed on the 29th. So this would be their agreement.
State would move to introduce into evidence State's Exhibit 501.
That'll be received.
With regard to kind of once that agreement was in place, you indicated that was meant to be a temporary arrangement.
That's right. It was going to be temporary, and it would be in place until we got the evaluation back and we were able to do something more permanent. And then when we made this agreement, you have to realize basically there wasn't any testimony from anybody. It wasn't really a trial where people got on the stand and testified. It was an agreement that the parties reached that we all tried to do the best we could under the circumstances.
And on that day, being June the 25th of 2010, was there a provision for Laura to have some visitation with the children that day?
Yeah, she did get to see both children that day, because you have to remember it was, she had not seen little Grant since well, actually, I think there might have been 1 visit or 2 visits in between, but she hasn't really had much time with little Grant since the middle of February. And she hadn't seen Gentle in about 10 days at that point. So we arranged that she would have some contact that afternoon.
And as part of this agreement, was there a provision that was put in place whereby Laura could, during the week when the boys were with Grant, that she could have contact and communicate with her sons by phone?
Yes, ma'am. I think we arranged for that each party would have reasonable telephone contact with the children while they were with the other party. And we defined reasonable contact as not more than twice per day and not more than 15 minutes per call. And we said the calls would be between 10 a.m. and 8 p.m. So like I said, we're trying to give them as much direction as we possibly can in this kind of an order.
Was there a time set up for this situation to be reviewed at a later date by the court?
Yeah, we went ahead and set a review date, I think, for August the 9th of 2010. Not really anticipating that we would have everything done by that point, but just kind of to keep up with the case and find out where we were.
And so in August, did anything happen further with the custody matter?
No, there was several court dates throughout the end of 2010, the beginning of 2011, where the lawyers met with the judge and we discussed where we are in the process, and then it was continued on to another court date.
And December of 2010, was there a filing made related to this case and by yourself on Laura's behalf?
That's correct. In December of 2010, I filed a motion for what we call contempt of court against Mr. Hayes because we believed he was violating this court order. We had alleged that Laura had been to Dr. Calloway and submitted a lot of her written materials. There was marital histories and other things that had to be submitted. Laura had arranged her appointments and basically done everything that she was supposed to do to move the evaluation forward. And we had gotten an indication from Dr. Calloway that Mr. Hayes was not being compliant in giving his written information to Dr. Calloway, and he hadn't arranged some of the appointments. And I believe also at that point there was an issue about the finances. There was a bill submitted by Dr. Calloway and Mr. Hayes had not paid it. And my understanding is in December the evaluation was suspended at that point until the payment could be made. So we filed a motion saying that Mr. Hayes was in violation of the court order by not proceeding with the evaluation.
And so this is some 6 months after that evaluation had been ordered and it had not been completed at that point.
That's correct.
What happened as a result of the motion that you filed in December of 2010 related to contempt?
Well, a couple of things happened right at the beginning of January of 2011. Number one is Mr. Hayes changed attorneys. So Mr. Hill, who was his attorney, withdrew from the case, and Mr. Coley, who is another attorney in Kinston, became his new attorney. So Mr. Coley and I went to meet with the judge about the contempt motion. And we had some negotiations in January that resulted in the judge entering an order in February directing the evaluation to resume.
And was there some adjustment made at that time about the payment and going forward with the evaluation by who was going to pay what?
Yes, ma'am. At that point, Mr. Hayes had paid about $10,000 toward the evaluation at that point. And we had gotten an estimate, I think, from Dr. Calloway that it was going to cost about $5,000 more to complete the evaluation. And Mr. Hayes' attorney, they didn't believe that they should have to continue to bear all the cost. So we reached an agreement at that time that was put in a court order that as to that last $5,000, we would split that cost. And Laura paid $2,500 and Mr. Hayes paid $2,500 so that we could complete the evaluation.
And you had indicated initially when you met Laura that you were representing her, she had just moved out of Grant Hayes' parents' house and moved into an apartment on her own, and that she didn't at that time have a job.
That's correct.
By this point, being December of 2010, had things changed for her?
Absolutely. She was, when she first came in to see me, her self-esteem was really low. She was just kind of getting out of a bad relationship, and she was kind of down on herself. But within a month after that, she had found a place to live in Kinston that she was happy with, where the children, would be stable. She had gotten a car, so she had transportation. She had found a job that she liked, working with somebody in Greenville, I believe. So yeah, she had started to turn all that around.
And were you aware at that point she'd also begun taking classes at the community college?
She had. She took some classes at LCC. And what she really wanted to do was this graphics design business. She wanted to do her own graphics design business where she could design like menus and different things for businesses. And I think by December she pretty much had that going to where she could make some money doing her own business but still have really flexible hours to be able to spend with the kids.
And so you indicated that at this point in December and in early January that there was an agreement reached that she would pay half of the remaining fee, the $2,500. So she was at this point in a position to make that kind of payment.
Yeah, and she did so immediately after we agreed to it. Yeah.
In terms of kind of going into January and February of 2011 with regard to this case, can you tell us what was happening at this point?
Well, it looked like the evaluation was going to resume. We wanted the evaluation to resume because we felt like it was going very well. And we really wanted to complete that evaluation. I remember Laura came to see me on March the 2nd of 2011 and to talk about the progress of the evaluation. And I remember at that point, we discussed that she felt like Mr. Hayes was getting kind of desperate. You know, he had tried to kind of stop the evaluation in January by not paying the money. We got the order and we paid our money, so it was going to continue. And she had some concerns at that point when she came to see me in March.
And was there anything you could do to push this along in March?
Well, in March, really what we were talking about was she had some concerns about what he might do. I mean, is what we talked about. We talked about how the evaluation was going to go forward, but she was concerned he may run with the children, you know, leave the state. Mr. Hayes has some ideas about he wants his children to be some kind of citizens of the world, and he travels a lot. He wanted them to grow up all over the world. She was afraid they might leave with him, so we talked about what would happen if he were to try to leave, and she was concerned that he might hurt her. You know, we talked about that as well.
And so she, when she came to you in March now of 2011, expressed some concerns, as you've indicated first, that Mr. Hayes might take the children and run. And
Yes, ma'am.
you talked with her about that. Were you able to, you know, go through kind of what would happen in that type of situation?
Yeah, we kind of walked through the different scenarios. If he were to take them and run to another state, you know, this is how we would handle it. He wouldn't be the first person, you know, who has done that we have to deal with that sometimes. If he would take them and run to another country, we talked about what the procedures would be there. We had tried to get I think in the earlier agreement we had talked about the kids did not have passports at that point, and I think we agreed that they would not get passports. And I think even this order provides that nobody would take them out of the country. So we already had a court order that was saying that neither party would leave the state of North Carolina with the children while the order was in effect. So we talked about that. Yes, ma'am.
And so that order which you've been referring to, and we've talked about it, which is State Exhibit 501, as you've indicated, had some very specific provisions, and that was an order of the court. That was what was ruling at that point. Is that right?
Yeah, it was an agreement between the parties, but it is approved by the judge, so it is absolutely an order of the court.
And did you impress upon Laura, you know, following that order to the letter?
Yes, ma'am. I mean, she understood it was a court order, and that was going to be our agreement till we got back to court and had a chance to hear the whole case.
You indicated that in March of 2011, when Laura came and spoke with you at your office, that she also had some concerns about her safety.
That's right.
And what did she tell you?
Well, she didn't know what he would do. Like I said, the prevailing thought was that the evaluation was going to come out in her favor, and that Mr. Hayes knew the evaluation was not going his way. So she was afraid that they might do something to her to try to gain advantage in the custody case.
And did you all kind of go through some various scenarios or put some ideas in place about how to handle her concerns in that regard?
Well, and I talked to her about, you know, don't put yourself in a position where something can happen to you. Don't, you know, you really don't want to be alone with him. You need to be, you know, aware of your surroundings. You know, I mean, it's just the general conversation that we have in a lot of cases when there's some concern about safety. Mm-hmm.
And that concerns that she expressed centered around the idea that the evaluation seemed to be going her way and not his way.
She felt really good about the evaluation. I mean, she thought Dr. Callaway was on top of things. Mm-hmm.
And at that point, she had been working with Dr. Callaway and providing information and meeting with her and that type of thing.
For months, yes, ma'am. Mm-hmm.
some point thereafter, did you become aware that Dr. Calloway had completed her evaluation?
Yes, ma'am. I received the evaluation on May the 17th of 2011. And what we do in this kind of a case is the evaluator will send a copy of the evaluation to both attorneys at the same time. So we really didn't know what was going to be in it until we received it. At the same time, the evaluator sends a sealed copy to the court. But that generally stays sealed until the trial, so the judge doesn't actually see the copy until the trial. But I received mine on May the 17th of 2011.
And do you recall if between meeting with Laura in March of 2011 and receiving the copy of the evaluation May 17th, 2011, whether or not you had any further interaction with Laura, anything further was going on with the case?
Probably not a whole lot, other than she might call to say, you know, have we heard anything yet?
Okay.
Mhm.
And so once you received the completed evaluation on May 17th of 2011, did you arrange to meet with Laura and discuss the results of that evaluation?
I did. I called her, and she came in the next day so we could go over the evaluation.
And with regard to that evaluation, was it something that was favorable to Laura in her custody case?
We felt like absolutely it was favorable for a number of reasons. One of the first things is the findings that Dr. Calloway made really, we thought, vindicated our position in the case. She basically found that Laura was not mentally unstable. That some of the things that had been alleged by Mr. Hayes in those initial papers the previous year, I mean, she didn't find that any of those things were true. So the first thing that jumped out at us was the findings about Laura were really exactly what we were hoping for. The next part, you know, some of the conclusions, well, I'll tell you before I go to the conclusions, she also made some findings about Mr. Hayes that we thought were right in line with what we said about Mr. Hayes. So there were some negative findings about Mr. Hayes in the report that were consistent with what our position was in the case. And then she made some conclusions too. Mm-hmm.
Well, let me ask you, kind of follow up on that. You said that Dr. Calloway's report had found some things that we said. As part of this evaluation process, did you, as Laura's attorney, actually talk with Dr. Calloway about some questions that you wanted to address as part of this evaluation?
Yes, the part of Dr. Calloway's procedure is that early on, both attorneys will have a joint phone conversation with Dr. Calloway, just so she can get each attorney's perspective and find out, okay, from my standpoint, these are what we think are the important issues in the case. So early on, I think one of the very first things that she did was have a joint phone conference between Mr. Hill, Mr. Hayes' attorney, and myself and Dr. Calloway, where we were both given an opportunity to tell Dr. Calloway what we thought the important issues were in the case. Mm-hmm.
And you indicated that this report that you received from Dr. Calloway on May the 17th of 2011 went on to make some recommendations. With regard to the custody of the children, what recommendations did she make with regard to?
She recommended a 50-50 split of custody. What she recommended is what she called a 2-2-3 split, which means they would be 2 days with one party, and then 2 days with the other party, and then 3 days back with the original party. So if Laura were to have this week, Monday and Tuesday, Mr. Hayes would have Wednesday and Thursday, and then Laura would have Friday, Saturday, and Sunday. And then the next week it would just be reversed, with Mr. Hayes having Monday and Tuesday, Laura having Wednesday and Thursday, and then back with Mr. Hayes for the weekend. So basically it would rotate every 2 weeks, and it would be a 50-50 split of time between each party.
And up until this point, the agreement that had been in place involved the exchanges occurring basically twice a week on that Friday and Sunday.
Yeah, because Laura had her every weekend, and so every Friday she would pick them up, and every Sunday. Mm-hmm.
And this, what was recommended, this 2-2-3, would involve lots more of those exchanges.
Yeah, we were basically getting 4 overnights every 2 weeks under the first schedule, and it was, her recommendation was actually 50-50, so it would have been 7 overnights every 2 weeks. It's kind of the way we look at it when we look at these.
And in terms to make that happen, it would involve a lot more contact between the parents and
Yeah.
having those exchanges.
It would be a lot more contact. You know, this kind of a schedule is more typical when you're dealing with younger children. I know from, and I'm, you know, I'm not a psychologist, but they tend to recommend younger children have shorter, more frequent visits. They think are better for younger children.
And in terms of your meeting with Laura upon receiving Dr. Callaway's report, I know you indicated that you felt vindicated, or she felt vindicated in receiving this report. In terms of the court proceeding, did you and Laura talk about what you could expect?
Oh, we need
Court as a
one more.
result?
We need one more? You can have the big roll.
Yes, in fact, she came in on May the 18th, and we went through the report. We pretty much walked through the whole thing, hit the high points, and talked about some of the issues in it. She was pretty pleased with the report as it was. We talked about then, since we had the report, we could go ahead and set a court date. In fact, myself and Mr. Coley, Mr. Hayes' attorney, we met with the judge on May the 23rd. So I got the report on the 17th. I went over it with Laura on the 18th of May 2011. And then we met with the judge on the 23rd of May and asked her to go ahead and set a court date. So we were, I think, with having that come in, we talked about we can now set a court date. People can come into court and testify. You know, she was going to get to tell her side of the story.
And that was kind of my next question, in terms of what would happen on that court date. Obviously, Dr. Callaway's report would be available to the judge, but did you also expect that there would be testimony and various character witnesses that would come forward?
That's right. This was going to be a full custody trial. So we expected the parties to testify. I had talked to Laura about getting together her friends and her character witnesses who were going to come into court and testify. We would have subpoenaed Dr. Callaway to appear and testify. You generally have to have her there to walk through the report and answer any questions about it. So we were working on getting that all together right after we got the report.
Okay, and you indicated that you met, I believe, on May the 23rd with the judge to
With
get
the
a
judge.
court date?
Yes.
And was one set at that time?
Yeah, shortly after that, we got a notice saying the court date was going to be August the 15th.
And again, that's the day that you expected to have a full custody trial at that point.
That's correct.
Now, Dr. Callaway had recommended a 50-50 split. Is that binding on the judge?
No, absolutely not. Well, I mean, that would be an important piece of evidence for the judge, and the judge may well agree with Dr. Callaway and decide to do that, but ultimately the decision is in the hands of the judge. So the judge can look at the whole picture, look at all the witnesses, look at Dr. Callaway's report and her findings, and then make a decision about custody. So no, the judge is not bound by that report.
And could it have been a 50-50 split, or perhaps even better for Laura?
It could have been. In fact, we felt like that 50-50 was the worst we would possibly do. In fact, we felt like with some of the findings about Mr. Hayes that were in the report, we really thought we could do better than 50-50.
And is that, when you say we thought that, I mean, that's something that you and Laura
That's something
discussed?
Laura and I discussed, yes ma'am. Mhm.
And you indicated that you had spoken with her about lining up witnesses. What instructions did you give her? What did you ask her to do?
We generally ask people to find several witnesses kind of from different parts of their life. You know, the judge doesn't want to hear, 3 people who go to church with you. So try to find somebody from church, try to find a friend that maybe you have outside of church. We don't want to see 12 relatives, try to find a couple of relatives and to kind of get a good mix of people who knew all different parts of your life. So she was working on that list, yeah.
And was that something that you kind of left up to her, told her kind of what type of people? We want kind of a cross section, but you picked those people?
Yeah, well, ultimately, I would want to pick the actual
Okay.
people. But the way it works is that early on, we're still 3 months away. I tell her to get a list together of who she thinks would be good witnesses. She gives me kind of a summary of who they are and their contact information, and then I generally call and talk to every witness. And then she and I would talk again, and we'd decide, who we wanted to use in the trial. Mhm.
And kind of during this whole process, from the time that you first met Laura and she retained you, had you asked her, or were you aware that she was keeping records with regard to interaction with Gran and the boys?
Yes, ma'am. In fact, I had asked her specifically to try to document everything that was going on. Part of the problem is just like that surgery issue. One party was saying the other one was blocking the surgery, and then she would say he was blocking the surgery. We had a lot of that in this case. In fact, I think we had occasions early on where one of them would be at the gas station in Wilson and say, I was there to get the children, but the other one never showed up. And then we would talk to the other party, and they would swear they were there at the gas station at the same time, and that he never showed up. So when you get that kind of situation, you have to say, well, you need to document everything. You need to try to record your conversations, because you just can't, something obviously is not right, and somebody's not telling the truth, so you have to document everything you do. So yes, I asked her to do that.
And did did that ever involve getting like a receipt from the gas station with the
Yeah.
time and?
That's one of the things we ask them to do. If you're at the gas station and he's not there, we'll go inside and buy something, get a timed and dated receipt so that you'll have it, and then at least you can prove you were really there. Because obviously somebody's not there, so we have to prove that. So we say, yeah, go in and get a receipt so that you'll have something to show the judge that you were there.
And in terms of recording, you knew that she was recording both, did you know she was doing voice recordings as well as documenting with writing down various interactions?
Yeah, I was aware she was doing both.
And was that anything that she shared with you, or you just knew she was doing that?
She had shared with me some of them about the recordings, but not a lot. Most of that information, once the evaluation was underway, I would say, she would call me and say, this happened or that's happened, and I would say, well, make sure Dr. Calloway knows about it. So I was trying to funnel a lot of that information into Dr. Calloway so she could put it together. And then we really didn't get to the point where we were going to pick and choose what we were going to use of the evidence in August.
You indicated that you met with Laura on May the 18th to go over the evaluation. Did you meet with her again after that?
Yes, I met with her on June the 28th of 2011.
And what was the purpose of you meeting with her on that day?
That was to get ready for trial. She came in that day. We had a pretty extended office conference, and we talked about what witnesses she was going to call. We talked about what other evidence that I might need to subpoena, if there were records that we felt like we needed from anywhere. We really talked about our witness list and got together a list of people we were going to subpoena for court.
And you had indicated on the prior meeting back in May that she had been feeling good about her chances and felt vindicated. On June the 28th, how was that feeling in terms of going forward into that hearing on August the 15th?
Well, she was excited. She was happy. We had been waiting, a year literally to do this. So, we got from June of 2010 all the way now to August of 2011. Like I said, we had been waiting a long time to get into court. We felt like it was going to go real well. So she was excited and pretty happy last time I saw her.
You said last time, did you see her after that?
I did not.
With regard to kind of the plans forward, you met with her on June the 20th, and you said you were getting ready for the hearing. Were there other things that she had to do when she left there?
Yeah, she was organizing all the things she had at home. She was organizing her notes and anything else she thought that we needed to present to the court. She was going to talk to some more of her witnesses, and we were going to get back together and kind of finalize things in July.
And during the time that you first met with Laura back in 2010, until you last saw her on that last office meeting in June 28th of 2011, in terms of those children, what was her focus?
Well, really during the whole time, everything that Laura did was geared toward getting custody of the children. I mean, that was her number one priority. And she would call me when she had a job opportunity, and she would say, how is this going to affect me being able to get custody of the children? You know, she would call me when she, you know, if she had a young man or somebody she was interested in, and she said, is this going to be a problem with me getting custody of the children? So really everything from day one, her priority was to get full custody of those children.
And you talked a little bit about when she first appeared in your office and presented that she lacked self-esteem and that type of thing. You talked about by December, you know, the changes that you saw in her. From December of 2010 until June of 2011, what would you say about you know, kind of where she was in her life in terms of work and that type of thing, and how things were going?
I mean, I think things were going great for her. In fact, when we were talking about her witnesses, I learned that she had connected with a church there in Kinston, a really good church. She was in a weekly Bible study that she went to through the church people, and I think they were really supporting her. That was important to her. She had pretty much come full circle within that year from when she walked in, and you know, she didn't have either child with her when I first met her. To by the time we last met, I mean, she had everything going.
At any point during your interaction with Laura Ackerson, did she ever discuss with you about accepting some amount of money not to pursue the custody of those children?
No, we never discussed that. It was never an option in our case. I mean, her priority was full custody, and we never discussed really anything less than that.
Thank you, that's all I have.
Do you have questions?
Yes, Your Honor.
Go ahead.
Good afternoon, Mr. Sergeant.
Good afternoon.
The custody dispute was between Laura and Grant, wasn't it?
That's correct.
During the time that you represented Laura, did she express concerns to you about her safety, any concerns about being in danger from Grant?
Yes, she did.
Tell us about that.
Yeah, on March the 2nd, specifically, I remember us talking about that Mr. Hayes was getting kind of desperate about the evaluation, and she was concerned that Mr. Hayes may hurt her or do something to her. And in fact, I know that she and Heidi Schumacher, her friend, had a deal that if something happened to either one of them, that the other one was going to contact the police.
Did she also share with you information about threats that Grant had made to other people?
She did.
Jackson?
Overall, he can answer. Sure.
I don't know about threats that Grant had made to other people. I mean, she had shared other information about Mr. Hayes, you know, having some violent tendencies, yes.
And what were those violent tendencies?
Well, I think she had indicated he was abusive to her when they were together. She told me that. And he would also, and when you say threats, he would say things like, not that he was going to do it, but that he knew people who could do things to her.
Did he ever use the word, or did she ever use the words, if something to the effect, if I can't get it done, my goons can do it?
Yes, sir. He would say he knew some thugs from the old days who could take care of Laura. Mm-hmm.
Did she ever indicate to you that he had told her that he had previously killed someone?
She did indicate that to me, that he had told her that.
Did she also indicate to you that he frequently had thoughts about killing his ex-wife?
I don't recall her telling me that, no.
During the, you testified previously in another trial,
Yes, sir.
do you recall? Do you recall being asked this question? Mr. Sergeant, yesterday when you were testifying, and I asked you about basically the little over a year-long experience you had in dealing with Laura Ackerson and assisting her during that time, did you discuss with her or did you have knowledge about her relationship with Amanda Hayes? You remember that question?
Yes, I do.
You remember answering, yes, I did.
That's correct.
Do you then remember the question, and did she?
Objection to reading from,
What he said at a prior time?
yes, sir.
Go ahead.
I would object to the question, not what he said at a prior time. For the lawyer.
Overall.
Do you recall being asked a question by Ms. Holt? And did she express to you any animosity or hostility with regard to Amanda Hayes?
I remember being asked the question, if that's what you're asking me.
And you gave a rather long answer at that point, did you not?
I don't remember how long the answer was.
May I approach the witness?
You may.
Mr. Sergeant, let me hand you what I have marked as Defendant's Exhibit number 59, and rather than have me read that answer, if you would read the answer that you gave to that question.
You can read it to himself or read it out loud?
Read it out loud.
Okay, thank you.
Well, first, why don't you read it to yourself first, okay?
Yes, sir. Yeah, I remember this.
Okay, do you intend to ask him to read that?
Yes.
So you're introducing at least some of the information from Defendant's Exhibit 59?
Yes, Your Honor.
All right.
The answer is she did not. In fact, during the time that I was representing her, one of the things we discussed is that Laura was actually more comfortable with Amanda being in the home with Mr. Hayes, mostly because during their relationship, Laura had done pretty much all the child care, the changing the diapers, the bathing, the day-to-day activities with the children, and Mr. Hayes had not participated a lot in that. And so she was a lot more comfortable knowing that Amanda was there, and there was another adult helping with the day-to-day care for the children. So actually, she felt more comfortable with Mr. Hayes's home because of Amanda, and I was not aware of any animosity between the two of them. I do know at one point in March of 2010, Laura actually sent a thank you note to Amanda for things that she had done for their children.
Have a moment, Your Honor.
Okay.
Sir.
Okay, any other questions?
Yes, Your Honor. Mr. Sergeant, what you've just relayed is that Laura felt more comfortable that her children were being taken care of with Amanda in the home.
That's correct. The context of that question was really in terms of when we entered the child custody arrangement, the temporary arrangement, that we were concerned that since during their whole relationship, Laura had done all the day-to-day care, and we're talking about two little children, like 10 months and 2 years old, and Laura had done all the diapers and all the feeding and all the bathing, and Mr. Hayes had really not participated at all in any of the child care. So it was somewhat of a comfort, certainly to Laura, to know that here was another adult in the household who was there to help with the kids during the week. So that was kind of the context of the answer.
Thank you.
Okay, thank you.
No further questions.
Anything further? Okay, thank you, Mr. Sergeant. Appreciate you being here. This witness is excused. Thank you.
Thank you.
All right, folks. I'm gonna have a little hearing regarding the next witness, I think, and so I'm gonna let y'all go to lunch. But I'm gonna have you come. It's gonna take us a few minutes. Let me have you come back. I know you don't need an hour and a half for lunch, but we're gonna need the time, I believe. So I'm gonna ask you to come back at 2:30, please. Please don't discuss the matter among yourselves. Keep an open mind. Don't form or express any opinion about the guilt or innocence of the defendant or any matter of controversy. We'll see y'all at 2:30. Thank you very much. All right, the jury's absent. We're still in session. I do note that Dr. Calloway is present, and Mark Sokol, I believe, who appeared on her behalf at a prior trial, is also here. And I had notified the prosecutor, I think last evening, to, at least as a matter of courtesy, to let her know that she'd be called today, and that if her attorney wanted to express any concerns at this trial, as he had expressed previously, I would be glad to hear him and her. Do you intend to call Dr. Calloway as a state's witness in this case?
Yes.
Okay. Would she be called this afternoon?
Yes.
Okay. Do you intend to attend to her as an expert witness? I believe she was called as a fact witness in the last trial, and we all had an understanding that she was being attended to the court as a fact witness. That, you know, people who have some expertise are sometimes called as fact witnesses and are sometimes called as experts, but there's a significant difference between the two. So.
At this point, we don't intend on calling her as an expert witness, despite the fact that she has some training experience as a psychologist.
Okay. I believe I received allowed the report of this witness in a limited way in the matter of Grant Hayes. Specifically, I allowed her report to be considered as it had any relevance or bearing upon the state of mind of the defendant, Grant Hayes, and the state of mind of Laura Ackerson at the time of Ms. Ackerson's death. Not necessarily to be considered by the jury for the truth of anything asserted therein, or as to whether or not there was a professional basis for the opinions given, or whether or not the opinions were professionally valid, but only to the extent that the victim and Grant Hayes knew what the report said, and they may have gained impressions from that report that caused them to take certain actions, in part based upon that information, and perhaps some concern of what a district court judge might do with regard to the custody issue. We're not here today, nor were we here in that trial, to litigate who would have gotten custody of the children, whether or not the evaluation was favorable to one side or the other, or how it was conducted, or anything of that nature, or what the district court necessarily would have done. I don't recall Dr. Calloway being asked anything about her, what she would have testified to at the hearing in the district court either. I think she was asked only what she did and basically what she reported, and was and what was part of her report. Do you intend to ask me to qualify her as an expert?
Your Honor.
And I won't do that. I will not qualify her. You would have to qualify her based upon how she answered your questions. Okay? So, all right. But we'd have to do that out of the presence of the jury, so I'm just kind of curious now as to whether or not you anticipate doing that.
We do not intend to ask that she be allowed to testify as an expert witness. We do, however, intend to elicit information from her about her experience and education in the psychological field, information that she has received in her experience and training. Essentially, we intend to ask her a lot of questions about what she might or might not know, having learned those things in her experience and her training, but we don't intend to ask her to express any expert opinions. It's more in the sense of information that she would know through her experience, but we're not going to go that extra.
In general?
Fairly general, but we don't intend to take that extra step of asking for any opinion.
All right. I don't know what that means, but I don't have a clue what that means. But I mean, I assume you have a valid basis to ask her if she was appointed by the court and what her qualifications were for the court appointment, what her background experience were to qualify her to make a recommendation to the court, and her knowledge and based on that background experience and concerning general concepts of psychological testing and evaluation and that sort of thing. Is that what you're saying?
I think that we're on the same page. I think that we intend to ask her what may turn out to be a lot of questions about things that she knows in her psychological training.
Okay.
We simply don't intend to ask her questions that would require that she be qualified as an expert.
All right. Well, I mean, I'm trying to understand what you're saying. You've used the term sociopath, psychopath.
Yeah.
Do you intend to ask her if she understands what the definition of a sociopath is, what the definition of a psychopath would be? Is that what you're going to tell me?
That's where we're headed.
Okay. As part of her background, training, and experience.
Exactly. That's where we're headed.
Are you going to ask her an opinion as to whether or not anybody involved in this case fit that criteria?
No, we are not.
All right. Okay. What?
Your Honor, I think we'd like to be heard before that happens, because essentially what this is doing is just putting in front of the jury, asking all these questions about what's a psychopath, and it's a thinly veiled attempt to correlate defendant Grant Hayes, the co-defendant Grant Hayes, meeting this definition. If the questions are just general about what constitutes a psychopath, what constitutes a sociopath, it's not relevant to this matter. There's no relevance whatsoever. If I were to ask Dr. Calloway in her training experience about other psychological diagnoses, I would be precluded from doing so because they're not relevant. So that would be our objection to that. I don't purport to know exactly how it's going to go, and maybe I should just object when it happens.
All right. Okay. Mr. Sokol, do you want to say anything?
Yes, Your Honor, because I think Dr. Calloway is troubled by the potential that, although she's not going to be asked to be qualified as an expert, in giving testimony about the definition of diagnoses or conditions, she is in fact being asked to testify as an expert, knowing more than we do as lay people about these things. And so she's concerned that that area of questioning goes beyond what she feels comfortable under her guidelines and rules a lot of this, that she is not been subpoenaed as an expert, hasn't been retained by anybody as an expert, and yet it sounds as if some of the questioning is going to be beyond the area of a layperson. What's a psychopath and what are the characteristics and
Well, she was appointed by the district court, Lenore County, as qualified to make a psychological evaluation based upon her background, experience, certification, to make a recommendation to the court with regard to the custody of two children, which required her to rely upon her training and experience as a psychologist. Certainly she could be asked in making any kind of an evaluation with regard to a child or anything else in child custody, how you go about doing that, and whether or not you look at the parents and any mental health issues that they may have, and how that affects your analysis and your evaluation in general, as opposed to specifically in this case, and including if she refers to DSM, any kind of a psychiatric evaluation or anything else. I think that's a valid inquiry by the parties from both sides. You know, and if you're an MD at an emergency room looking at a gunshot wound, you may be called as a fact witness to say, I opened somebody up and they suffered a gunshot wound. We all know what that looks like, pretty much. But asking opinions as to how it was inflicted and that sort of thing, all of a sudden you get beyond that. So I'm not sure exactly what your client's concerned about.
her guidelines permit her to testify as an expert within the realm of the assignment she was given, subject to the issues and her inferences and so on.
Okay, I don't.
And all she's saying is that she feels as if her guidelines say she cannot be testifying about inferences she made or opinions she has about things outside of what she was retained to do.
Okay, well, I respect that. I respect her concern about what she is ethically permitted to do in this courtroom based on her testimony as a psychologist. I may determine that the interest of justice require that she exceed what would normally be expected of her under her own guidelines. Right, and I was trying to find out how far beyond those guidelines that anyone's going to ask her to go, and I can't tell right now, but I do believe that this is a legitimate inquiry from both sides, in good faith made. I will not expect her to answer any question that she does not feel qualified to answer. If she's asked some question with regard to some concept that she is not familiar with, or an opinion with regard to the application of that professional concept to certain facts, and she's not comfortable answering that, or not, she doesn't feel like she's qualified to answer that, or she has no opinion about that, I hope she will freely indicate that she does not have such an opinion. But I will compel her to answer any question that comes up during this trial that's objected to, and I decide that it's appropriate for the jury to hear her answer to the question, and I'll just either sustain the objection or overrule the objection, and then she can respond accordingly. And I appreciate her bringing that to my attention again, and I understand her professional concern. Anything else? All right.
Just one thing, Your Honor, we've all.
Right, right. There's one. There was a reference in the in Dr. Calloway's report in which the term, I think, eradicate was obliterate. Okay, I'm sorry, obliterate was used. Because that term is maybe taken in a number of different ways And I'm not sure that it has a specific meaning as it's generally understood and used. The jury could reach different conclusions about what was intended by that term in this report, and therefore I'm going to instruct her not to use that term or make reference to that term unless the court specifically, in the context of a question, believes it would be appropriate. And then if I do, I will instruct her that she can make reference to the term. But unless I do, I'm not going to allow her to make reference to that term from this report as it relates to this defendant. I did not make that ruling in the previous trial, but as with regard to this particular defendant, I believe that the jury may get the wrong impression if that term is used. All right? Anything else?
No, Your Honor.
Okay. Thank you. Sheriff, we're going to be in recess till 2:30. Thank you.